For immigration law,
speak to Tan Law Solicitors.
for family law,
Speak to Tan Law Solicitors.
for employment law,
Speak to Tan Law Solicitors.
for wills and probate.
Speak to Tan Law Solicitors. At Tan Law Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.
Hello, my name is Andrew Nyamayaro. I'm the principal of Tan Law Solicitors, which is based in Coventry in the United Kingdom. Today I'm going to make a brief presentation on the topic regarding children and immigration as part of family members. Where the children are in the United Kingdom, ordinarily they will assume the immigration status or the nationality of their parents. So if a child is born in the United Kingdom and the parent is British, ordinarily that child is a British citizen. Where the parent has got indefinite leave to remain, then the child will have British citizenship when they are born to a parent who has got indefinite leave to remain. The situation might be different to children who have been born before the parents assume indefinite leave to remain. In that case, the children will then need to naturalize to become British citizens. Where the parent have got limited leave to remain, or for example, they are a student, the parents, or they are on a skilled worker route, or they are on any other type of limited leave to remain, then the child will assume also a limited leave to remain in line with the parents and will follow the same route that the parent has. Where the parent is in the country illegally and does not have any legal status in the United Kingdom, then that child will also not have leave to remain of any sort in the United Kingdom. The child will then have her own private life or her own rights accruing to her as he or she grows up. And as such, the law recognizes that when the child has been in the United Kingdom for about 7 years or so, the child can be at a stage whereby he or she has accrued their own private life, and therefore, in terms of the law, the immigration rules, and Article 8 and private life, the child can be granted leave to remain. Now, the child might be living with someone who is their sole carer, or there could be shared custody between the parents, but the child cannot remain alone in the United Kingdom with the parents being asked to leave the United Kingdom. In that case, ordinarily, the parents as well will be granted leave to remain. And in most cases, it will be leave to remain, which is given 2.5 years. And you will have to spend 10 years on the 2.5 years until the child or the parents and the child have done 10 years. And then after 10 years, they will then be qualifying for indefinite leave to remain. All these applications that we are mentioning now are applications that you need to pay a fee to the Home Office, and the fees will depend on the type of visa that you are applying for and the type of leave that you are applying for. Again, in terms of the immigration rules, where a child or a person is now over 18 but under the age of 24 but have spent at least half of their life in the United Kingdom, they can also qualify for leave to remain, and again they will be on the 10-year route. It is encouraging to note that the Home Office has produced a concession, a new guidance regarding children who have spent half of their lives in the United Kingdom. And the Home Office has considered that instead of them doing 10 years to get indefinite leave to remain, now they can do 5 years and get indefinite leave to remain. So if a child has spent about half of their life in the United Kingdom and they didn't have any leave to remain, and now they have leave to remain, instead of doing the 10 years, then they can get their indefinite leave by doing 5 years, which is a move in the right direction by the Home Office, a move that can be applauded. because the child would have spent a lot of time, and the chances are that the child is going to remain in the United Kingdom for a long time. Where a child turns 10 and has been in the United Kingdom and was born in the United Kingdom with or without papers, that child accrues a right to naturalize as a British citizen. The child becomes a British citizen, but they has to naturalize so that they get the full benefits of being a British citizen. So at 10 years, a child can naturalize to become a British citizen. We have spoken of children that have been born in the United Kingdom, or children that have come to the United Kingdom and are currently in the United Kingdom, on how immigration might impact or affect them. We know that the Home Office still charges naturalization fees, although the court said that it is unlawful for them to charge the naturalization fees. It is always important for the Home Office to consider the best interest of the minor children in every decision that they make. And even where you think that there might be no grounds to apply for, but the best interest of the children is always a consideration, a primary consideration for the Home Office in making their decisions. For children born outside the United Kingdom, or children that are outside the United Kingdom, they have to apply for entry clearance. If you're outside the kingdom, the United Kingdom, if a child is outside the United Kingdom, they have to apply for entry clearance. Again, children that have been born to a British citizen and are the first generation will be British citizens and can apply to get their British passport as someone as a child who is outside the United Kingdom. There are other various ways in which children can accrue um, their rights, which I will not comment on today, through ancestry or other rules that might be there. However, I want to comment briefly on an immigration rule that is normally used by most people to try to bring their children from outside the country. If the sponsor or the parent have got refugee status, then the child can come under family reunion, especially if they're pre-flight family member. If they're post-flight family member, then certain rules might apply, which are different from a pre-flight family member. So if it's a post-flight family member for a refugee, then, for example, fees might be paid. The refugee has to meet the financial requirement and so forth. But if it's a pre-flight, then there's no need for the financial requirement, as long as and the application is free as well. So the rule that I want to touch on in this presentation is the rule which is called the Rule 297 in the immigration rules. So this rule states that the requirements for indefinite leave to remain in the United Kingdom as the child of a parent or a relative present and settled or being admitted for settlement in the United Kingdom. The requirements to be met by a person seeking indefinite leave to enter the United Kingdom as the child of a parent or a relative present and settled or being admitted for settlement in the United Kingdom are that he, and he includes she, is seeking leave to enter, to accompany or join a parent or a relative in one of the following circumstances. Both parents are present and settled in the United Kingdom. I think that is one of the simplest ones when you're doing the application, because both parents are in the United Kingdom. The child was staying, say, with a grandmother or an uncle who can no longer support that child, or for another reason they cannot stay with the child. So in that case, both parents can just make the application, or one parent with the other supporting, that the child can join them in the United Kingdom. The other situation is where both parents are being admitted on the same occasion as settlement. So on that occasion, then the child can also be a dependent on the application together with the same parents that are applying to come to the United Kingdom. C, one parent is present and settled in the United Kingdom, and the other is being admitted on the same occasion for settlement. So in that case, the child will be accompanied by the other parent to join the parent who is already in the United Kingdom. So that should also be a fairly simple situation to deal with, because the child who can't remain without both parents or one of the parents in whatever country that they are coming from. D. One parent is present and settled in the United Kingdom or being admitted at the same occasion for settlement as the other parent is, and the other parent is dead. So, where the other parent is dead, obviously you need to prove that he or she is deceased. You've got the death records, you've got the death certificate, any other evidence that proves that the person is deceased and that the other parent is coming to the United Kingdom and they are coming with the child. A. One parent is present and settled in the United Kingdom or being admitted on the same occasion for settlement and has had sole responsibility for the child's upbringing. This is one of the most common application grounds that is used by parents, particularly in situations where one parent is in the United Kingdom and the other parent is in the host country where the child is living, or the whereabouts of the child is not known. In those particular circumstances, we want to prove that the parent here has got what is called sole responsibility, which is a legal term. They are the ones who have got the responsibility to make the decisions relating to the child's life. What it means is that that parent in the United Kingdom makes all the major decisions for the child. They decide which school they go to. They decide which church, which mosque, um, which activities, which doctor, which things they do. They are all decided by the parent in the United Kingdom. The person who is living with that child in the host country is just about an agent of um, the parent in the United Kingdom. So it could be, in some cases, an uncle, an aunt, the grandmother, and any other relative or third party person who has been given some who has been given the right to stay with the child, at least briefly or temporarily, by the parent. So sole responsibility has to be proven, and the law or the arguments that have been put forward is that financial responsibility alone does not amount to sole responsibility. There has to be a lot of considerations. Where you have to look at the financial requirements, the moral requirements. You have to look at all the other requirements, the food that they eat, the supply that you give them, looking after them, all the sort of support a child there is expected to have is coming from the person who has got the sole responsibility. Okay, so sole responsibility is one of the grounds that people used to apply to for their children to come to the United Kingdom, and financial responsibility alone is not sufficient. You have to look at the spiritual responsibility, the moral responsibility, the social responsibility, and so forth for the child. The ground E is that one parent or a relative is present and settled in the United Kingdom or being admitted on the same occasion for settlement, and there are serious and compelling family or other considerations which make exclusion of the child undesirable and suitable arrangements have been made for the child's care. Again, this is one of the grounds that causes a lot of refusals by the Home Office, where one parent or a relative is present in the United Kingdom or are being admitted at the same time, and they are serious or compelling family considerations. So we have to look at the environment where the child is living, the circumstances that they are living. That child might be living alone, or might be living with an old relative, or might be facing some abuse, or facing other life difficulties, or the rest of the families in the United Kingdom, and he or she is alone, and there's all sort of difficult things, which makes it the exclusion of the child undesirable, even when the other parent is within that country where the child is, but the living arrangements are not so suitable. For example, the other parent could have remarried, or you've got mental health problems, and so forth. So the Home Office has to consider those circumstances. And it is always advisable, particularly for paragraph E, so responsibility, and paragraph F, maybe to include expert reports from social workers who can then go and visit the child if that is possible, assess their living conditions, and they will interview the child, the people that they're living with, maybe the school or other people from authority within their lives, and then give that social worker report to the Home Office as part of the bundle that you submit as evidence for the application. So those are the grounds on which someone can make an application for their child who's outside the country. When the person making the application has got indefinite leave to remain or settled in the United Kingdom. Where the parent or a relative has got limited leave to remain, then it will be under Appendix FM, which has to be considered, and they have to meet the financial requirements and the rest of it. But I'm not going to touch on that today. So the child must be under the age of 18. And although sometimes you might have to say that even a person who is over the age of 18, who is still dependent on the parents, and you can prove it, might also be able to come to the country on that basis. But that is a tough task. And the child should not be living an independent life, is unmarried, and is not in a civil partnership, and has not formed an independent family unit. So effectively, they're still part of your family, and they are still dependent on you and being a member of your family. That child can and will be accommodated adequately by the parent or parents or a relative without recourse to public funds in accommodation which the parents own or exclusively occupy. So it means that when the child comes, they don't have to make the family or themselves have to go on claiming benefits as they are commonly called, but it's public funds. And they are living in an accommodation that is owned or rented exclusively, if you underline the word exclusively, by the family. So not being shared by other families or not being shared by other people or not. So it should be exclusively so there should be some exclusive occupation. It could be a room, two rooms, as long as there is no statutory overcrowding, which is there. And again, you need to get a report that there will be no statutory overcrowding. So some councils do those statutory and statutory overcrowding reports, or private companies can do that as well to get that report. And then the other consideration is that the tenant will be maintained adequately by the parent or parents and or relative of the child is seeking to join without any recourse to public funds. So the government tries to discourage people to go on benefits or to claim benefits, particularly because they've brought someone from outside the country and they couldn't have or cannot afford to look after that child themselves. And the child has got entry clearance to enter that capacity, and they do not fall under the general grounds for refusal. So general grounds for refusal, for example, might mean that they do not have a ban that is imposed on them, and they are a person of good character. They've not been, shown any deceit or wrongdoing, and so forth. So those are some of the grounds for a refusal that might be raised. So have touched on children that are in the United Kingdom, and I've also touched on children that are outside the United Kingdom. I would like at some time to comment and give a presentation on family law, particularly maybe relating to children. Some of the inquiries that we get from our clients is when a single parent is staying with the children, should they be able to travel with them to another country without the consent of the other parent or even the knowledge of the other parent? How can you make the other parent contribute to the welfare of the child financially or even physically? Because parents, particularly men, who will not be contributing to the maintenance of the children, to the upkeep of the children. Or some of the situations that we deal with is when one of the parents has got, well, men really mostly, they have the British citizen or have got the indefinite leave to remain, but are refusing to support the application for a passport or the application for a visa, indefinite leave to remain, or whatever it is for the children. There could be some recourse that could be available through either mediation or through the courts of law. Coming to the conclusion of this presentation today, my name is Andrew Nyamayaro. I'm a solicitor at Tanlaw Solicitors. And as usual, in our disclaimer, please treat this as general information. If you require specific, particular legal advice, go and see a lawyer, or you can come to Tanlaw and we'll be able to advise you accordingly and specifically to your circumstances. Thank you so much.
Immigration law.
Speak to Tanlaw Solicitors.
For family law.
Speak to Tanlaw Solicitors.
For employment law.
Speak to Tanlaw Solicitors.
For wills and probate.
Speak to Tanlaw Solicitors. At Tanlaw Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.